Have you ever heard of someone using land for 20 years and then becoming the owner of it? This is a real thing. It's called adverse possession and something we have dealt with many times. Stick around for a few minutes and I'll tell you all about it. Hi, I'm Paul Zimmer, a real estate attorney servicing all of Wisconsin. If you've ever wondered whether someone can legally take ownership of land just by using it over time, you're not alone. Today I'm going to break down the law of adverse possession for you and explain what it takes to make a valid claim and walk you through what to watch for here in Wisconsin. Adverse possession is a legal doctrine that allows someone to gain ownership of land that they don't actually hold title to, if they've possessed it in a certain way for a long enough period of time. That might sound strange, but the idea is based on rewarding individuals who treat property as their own and putting a time limit on how long a landowner can neglect or ignore their own property rights. But, and this is important, not just any use counts. Wisconsin law lays out strict requirements, and we're going to walk you through them now. To successfully claim adverse possession in Wisconsin, a person must prove 5 key elements, and all must be met continuously, usually for at least 20 years. The first is actual possession. Actual possession means that the person must physically use the land, not just say that they intend to. The use has to show control over the land, like an owner would. Number 2 is exclusive possession. The possession can't be shared with the legal owner or with the public. The possessor must be using the land in a way that's solely their own. Number 3 is open and notorious possession. The use must be obvious. It can't be hidden or secretive. The true owner must have been able to notice the use if they were paying attention. It's about giving the owner a chance to object. Number 4, continuous possession. The possession has to be uninterrupted. If someone leaves for months or years, or if the true owner reclaims control, the time clock resets. Now this is a big one. Even a short break can disrupt a claim. Number 5, hostile possession. Now hostile doesn't mean aggressive. It means without permission. So if the property owner gave you permission to use the land, then it's not hostile, and that defeats an adverse possession claim. In most cases, Wisconsin requires 20 years of continuous adverse possession. But there are some exceptions. First, if the person pays property taxes on the land that they're claiming, the required period can drop to 10 years under certain statutes. And second, claims based on record title, like if someone thought that they owned the land due to a title issue, this may also qualify for a shorter time frame. These exceptions are technical and they require very specific documentation and facts. Further, the time period doesn't have to be solely by you. The time period where your predecessor used the property, such as the former owner of your property, can also count toward that 20-year time period. If you're making a claim or defending against one, you need to also be incredibly specific. You'll need to show exactly what parts of the land were used, how they were used, and for how long. Vague memories or assumptions won't cut it. Photos, surveys, tax records, and testimony from neighbors can all be critical evidence. It is also helpful when proving a claim for adverse possession to be able to show what's called a substantial enclosure. A substantial enclosure is something like a fence or other evidence that demarcates the boundary of the disputed property area. And here's another important point. You cannot make an adverse possession claim against the government. Public land is exempt, period. If you enjoyed the content in this video, don't forget to like and subscribe to our channel for more insights on real estate law in Wisconsin. And if you're dealing with a property boundary issue or possible adverse possession claim, reach out to our office. We're here to help.